Welcome, welcome, welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast. Big hello to everyone in between. My name is Dan Balkaran, as you see on the screen, and I'm an employment lawyer at Samfiru, Tumarkin, LLP. As always, Canada's leading employee-side employment law firm. So I'm going to be answering all of your questions about employment law for the next half an hour. As always, some housekeeping. If you have any questions, or want to contact us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Please send us your questions as soon as you can. We have one or two kicking around, but certainly would like to get them more in early so I can answer them early rather than having them all backloaded in the session. Okay, let's get started. Dan asks, I was wondering about how long it would take to get my severance pay after I talk to an employment lawyer. So there's two types of severance. So if you're provincially regulated, which 90 to 95% of us are, there are two types of severance. You're going to get some severance by default if you're terminated without cause. Without cause just simply means that the employer did not have just cause to terminate you and provide you with zero. So, and that would be for, egregious events like coming into work drunk or punching your boss in the face or something like that, or stealing or theft or fraud or that kind of thing. So barring just cause, you're going to get severance if your termination date happened today. Okay, so you're entitled to it, and not to get too complicated, but you're entitled at law to something called notice. Okay, and that's the only thing you're entitled to at law. That's a heads up of your termination. So, hey Dan, sorry, we're going to terminate your employment in 6 months. Bad news is that's going to be your last day. The good news is you're going to continue to draw a paycheck for 6 months, and we'll give you time off to look for another job, and hopefully you get one so you're not unemployed for very long, if at all. That's notice, and that's what you're entitled to. But most employers, in my experience, about 95% choose to terminate today. And so when that happens, the notice you're entitled to converts into, you still get it, but because they can't actually give you the notice, it converts into money, and that's what we call severance. So I'm just going to call it severance for the rest of this session, because people understand intuitively what that is. It's money for termination. Your question is how long it would take to get severance. Well, there's two types of severance if you're provincially regulated: small severance, big severance. Small severance comes from the Employment Standards Act, and it's roughly 1 week per year of service to a maximum of 8 weeks. So not very much. Big severance is closer to 1 month per year of service to a maximum of 24 months. So quite a bit more. And what determines which one you get is the language of your employment contract, and certainly those things could often be your entitlement to it, and how much you get can often be disputed by the employer. And so your question is, how long would it take to get severance pay? Well, it depends. Depends what your claim is worth. If your claim is worth $250,000, it's probably going to be a substantial fight over it. If your claim is worth 25, might be less of a fight over it. So it depends on how much your claim is worth. It depends on what the language of your contract says. It depends what the other ancillary issues are. Are there fatal issues on your case, or potentially fatal issues on your case, such as just cause or forcibility of termination clause? Did you resign? There's all kinds of, there's a whole host of issues that could occur in employment law. So it depends on that. And then more importantly, it depends on the willingness of the parties to compromise. So is the employer willing to pay a reasonable amount of money? Or are you willing to accept less money than 100 cents in the dollar? And so somewhere in there lies a deal. Most of them will eventually settle. In my experience, about 99% of them settle. It doesn't make sense for most cases to go to trial. Sometimes it does, but most times it doesn't. And so, how long it takes to get there depends on the disposition of the parties to a large extent. So no one can answer that with any sort of certainty. Depends on your case. But I recommend if you've got, if you've been terminated and you believe that you have significant severance pay coming to you, I recommend that you talk to an employment lawyer right away. If you need to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821 $5,900. Okay. Any questions we have? Only a couple. Linda asks, when being asked by your employer to move to a new work location, how far is too far? If you don't drive and use transit, does that factor into it? Well, okay, so there's a few different questions in there. So if your employer says, Linda, we're moving you from office A to office B, and office B is 40 minutes away from where you live, and office A was only 10 minutes away, can they do that? Now, that's really the substance of your question. Well, actually, the substance of your question is how far is too far, and I'll get to that. So can they do that? Well, if it's a reasonable distance from you, yes, they can. Or if it's contemplated in your contract, yes, they can. Or if it was reasonably contemplated by the parties at the time of contract formation, so the time that you started at your employer, you knew they might move you across the province, and you were okay with that, and you understood, then yes, under all those circumstances, they can move you. What is a reasonable distance is really, for most of us, what it's going to come down to. And the rule of thumb, and I'm sure there are different cases on this, but I've sort of looked at it as an hour drive. You do it in an hour drive. An hour drive is not fun. It's a long drive, but I live in Vancouver, and every day people commute from Langley to just a suburb of Vancouver to Vancouver to go to work, and it's about an hour in rush hour. And every day people do it. An hour there, an hour home. So, I think it's probably reasonable. Beyond an hour, it starts to become unreasonable. So, but if you don't drive, that's an interesting question. So I think that the fact that you don't drive, if it's more than, you don't have a car, then the employer might have to provide you with some sort of transportation. But if it's you don't drive because you don't have a license, or you're afraid to drive, or what have you, that could be a factor that makes it unreasonable for them to move you. I don't think you don't use transit is a reasonable response to like if it's in an hour or within an hour by transit, and you just say I don't use transit. I don't think any court would accept that, and I appreciate that a segment of the population doesn't want to use transit anymore after the pandemic for health safety reasons, unless you had a significant health vulnerability that would make taking transit an unnecessary risk, and you had a doctor's note that said that. I don't think you can say from a reasonability perspective that you don't use transit. I don't know how taking transit would be too substantial a risk for your health, but going to an office wouldn't be. So, but generally speaking, I don't take transit as probably not an acceptable response to a reasonable move. Okay, so let's just say they move you too far, though. What is the remedy, right? So if it's an hour and a half by car away and it was 10 minutes, is that too far? And it's not contemplated in your contract. Yeah, I think that's probably too far. I'm not basing that on any firsthand knowledge of case law, and I'm open to being wrong on that. But at some point, it becomes unreasonable, and at that point, and I usually use the hour barometer, but an hour and a half, I would say, is too far to ask someone to drive when they didn't have to do that before. So at that point, can you argue that your contract of employment has been constructively dismissed? Yes, I think you can. Now, it's very important that anyone who's listening to this, if you think your employer has changed a fundamental term of your employment that you don't agree with, such that you've been constructively dismissed, do not initiate your constructive dismissal without talking to a lawyer first. It's too hard. Constructive dismissals are too complicated, and too much can go wrong. Always talk to a lawyer first. If you need to reach us, you can do so at employmentlawyer.ca, helpemploymentlawyer.ca, and 1-855-821-5900. Okay, so they've moved you an hour and a half away in my hypothetical example, and there's no provision for that in your employment contract, and there was no contemplation of that at the time that you were hired. Is that a constructive dismissal? Probably. So why would you initiate a constructive dismissal? A constructive dismissal is where your employer, through its actions, de facto terminates your employment. So it doesn't explicitly terminate you, but it indicates through its actions that it has terminated you. And the standard way to get there is through for a breach of a fundamental term of your employment, like distance to work. Okay, and so why would you want to do that? Well, you do it because after you've been terminated, either constructively or explicitly, you then have a right to severance. Okay? And then it depends on whether or not you'd want to do that depends on the amount of severance you have coming to you. You know, if you got 75 grand potentially coming to you in severance, then maybe you do that because it makes sense in the circumstances. But if your employment contract limits you to Employment Standards Act minimum notice, and all you get is 8 weeks severance, then maybe it doesn't make sense for you to do that. So these are all complicated questions that you need to discuss with a lawyer. Anyone who is claiming constructive dismissal or thinks they're going to claim constructive dismissal should talk to a lawyer and do so right away. And I say right away because you have a finite amount of time to initiate your constructive dismissal. Okay? The Supreme Court of Canada has accepted 2 months after the date of the unilateral change to a fundamental term of your employment was imposed upon you. I've seen in BC a case that says as much as 3 months, but you don't have unlimited time. If you wait 6 months, you can't go back and say, oh, you moved me 6 months ago, I'm claiming constructive dismissal. Well, wait a second. The court will say, well, wait a second. You accepted those terms by working under them for 6 months. So you've got to move quickly if they've imposed this change upon you and you think it's a constructive dismissal, but you can't do it without legal advice. So lots of stuff there, Linda. I would very much talk to a lawyer as soon as possible. Okay, a couple more questions. Clint asks, can someone claim constructive dismissal even if they've decided to resign due to the stress of the situation? Yes, the short answer is yes, you can. You can claim constructive, like if you quit because of, there are two ways to get to constructive dismissal. One, as I just said, was a breach of the fundamental term of your employment. And two is, I'll just call it repudiation. It's where the employer, through its actions, has effectively repudiated its contract of employment with you. It has indicated that it doesn't want to be your employer anymore. That second one is very hard, though, and that's what you're really talking about, stress of the situation. Was the employer treating you intolerably such that anyone, a reasonable person in your position, would have resigned? Right? And that's tough. You got to go to court to go along with that and agree with that. And it's very rare. It happens, but you're going to need a lot of evidence. So, it doesn't mean that there isn't value to your claim, but that's the hardest way to get to constructive dismissal. So I would definitely explore it with a lawyer as soon as you can, but stress of the situation has to be more than, my boss, and I, I got a better, I'll give you a better one. I've had callers and clients who thought a bad annual review created an intolerable amount of stress, and that's certainly not going to get you there. Right? That's just a bad review that you work through with your employer, and you try to improve and all that stuff. So it's got to be something significant and objective. It has to be. You're basically asking, if it ever got in front of a judge, the judge would ask himself or herself, if I put myself in Clint's position, could I work there as well, or would I be forced to resign? And if the answer is no, I couldn't work there, and yes, I would be forced to resign, then you've got something. So it's got to be objective, right? So, but to get there, you're going to need a lot of evidence, right? Or if your evidence is all from you, because it's one-on-one discussions with a particular manager that was a problem, for example, you have to be believed, and your evidence has to be preferred over that of the other person. So, and that can be challenging. So talk to a lawyer right away, Clint. But it's the toughest road to get into constructive dismissal is what you're talking about. And just generally for people who think they might have a claim, or they think that let me rephrase that. for those of you who think you might have a constructive dismissal claim, or you're thinking about resigning and claiming constructive dismissal, don't act until you get legal advice. It's too difficult. It's too difficult. It is, let me rephrase that. Constructive dismissals are too difficult for you to run on your own. And sometimes when you make decisions, if you resign in the heat of the moment and then you go to a lawyer 2 months later, the lawyer can't fix it, right? There are only so many things the lawyer can do. So getting the benefit of legal advice, guiding your actions ahead of time, or at least advising you ahead of time as to what your legal options are in the case of a potential constructive dismissal, is always the route you want to go. So talk to a lawyer right away. Generally, talk to a lawyer now, but just for anybody else who has a potential constructive dismissal claim, talk to a lawyer ahead of time before you take any precipitous action. And again, if you want to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Delia asks, if you're put on working notice and the other employer offers a different job that you are not accustomed to, can they argue if you don't accept, they don't have to pay severance? Well, so as I said at the beginning of this session, your only entitlement is to the working notice. So working notice is, hey, Delia, I'm going to terminate you in X amount of months. I'm going to terminate you in 6 months, and you're going to work here for 6 months, and that'll be your last day. Hopefully you get a new job before that. Okay, that's notice. Now, if they offer you another job, and you don't take it, and it's reasonably similar or substantially similar to your existing job, so if the pay is more or less the same and it's not a substantial change, like you're not going from manager of customer service to janitor, but you're going from manager of customer service to supervisor of billing or something, I think there's an argument that they don't have to continue with I think they might be able to say, well, we don't have to continue with the working notice because you failed in your duty to mitigate. But I've never seen that before. So I'd want to take a look at that a little more clearly, because they did provide you working notice to a specific date. I think if there's a severance, so quite often what employers will do is they'll provide you with some amount of working notice, and then at the end of the working notice, they'll provide you a severance. And so if that's what's happening here with Delia, then the question is she entitled to the severance after the working notice if they've offered her a different job that she doesn't accept? And I think if it's substantially similar, I think that would be correct. They don't owe you any severance at that point. You have, and the legal principle there is that you have a positive obligation to, after you lose your job, to make reasonable efforts to look for replacement employment. Okay? And if you don't make reasonable efforts, the court can deduct months from your severance in the event that you're entitled to common law severance. But if an opportunity is presented to you that is effectively the same or very similar or reasonably similar to the job that you just lost, and you don't take it, your severance claim is stopped right there. Okay, and so if an employer says, and I see this sometimes when there's two companies, they're like sister companies, and there's a termination from one, and then the other one offers them the same job or more or less the same job. If that person doesn't take that job at the other company, yes, their severance claim is probably extinguished at that point. So yes, I think if the job is substantially similar, but it depends on the details, right? Like if it's wildly different, or there's a reasonable reason as to why you wouldn't want to take it. Pay cut is too much, or it's a huge diminishment in prestige, or there's just no possibility for an advancement, or whatever, or there are no benefits, although that probably wouldn't be enough. Yes, you might be justified not taking it, but if it's substantially similar, you're probably going to have to take it, and you probably don't have any entitlement to severance at that point. Is there a reason why you wouldn't want to take it? I mean, you say you're not accustomed to it, but people change jobs all the time, and there are changes to jobs, and they have to change industries and learn new systems and new ways of doing things. So, it really comes down to pay, prestige within title, and reasonable similarity of the skills, right? So it's still working on a computer, still talking to people on the phone, answering questions that are reasonably similar. Sure. If it's a question of degree as opposed to a substantial change, yeah, I think you might have to accept that job, or get no severance if you don't. Adriana says, "Can I get fired from not returning from I don't know what that is, FMLA leave the day I was supposed to?" Why? Sorry, I feel I should know what FMLA leave is, family leave. But if you're on some sort of medical leave, let's say, or you're on maternity leave, open communication with your employer, I think, is what you need to have. If you don't show up for work at some point relatively quickly, a few shifts in, you're going to effectively abandon your position. So yes, I think that it's not so much that you got fired. I think you resigned, right? And then you have no claim to anything. So if you can't return from your leave the day you're supposed to, right, from your leave to work the day you're supposed to, then you need to have open communication with your employer as to why. Oh, my flight got extended, or my flight is delayed, or my trip is extended. Can I stay for another week? Like, just have open discussion, or have discussions about it, because if you do nothing and just don't show up, I think you're, especially, for one day is one thing, but as the days start to stack up, you're going to be in serious danger of having effectively resigned. Linda has back. One more question. My partner's mother is being let go after 19 years. Her position is being made redundant. She is 61 and offered 19 weeks. Is that enough? I don't know the particulars of her employment contract, but 19 weeks seems to be substantially enough over 8 weeks that her contract may not be enforceable. The termination clause in her contract may not be enforceable, such that probably not enough. I don't know what she did for a living, but I suspect that she's going to want to talk to an employment lawyer right away. So, this is not specific advice. I haven't seen the contract. I in a one paragraph question, I cannot possibly know your partner's mother's legal position, but my instinct is that she might have something there, and she should talk to an employment lawyer right away. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Oh, Linda follows it up with, they want her to sign by Tuesday. If she doesn't, can they refuse to pay her severance? So this is a common tactic that employers will use. You won't get this extra money if you don't sign by X date. Now, generally, the reason why they're doing that is because they want to limit their financial liability to the terminated employee. And so they're scaring the employee into potentially losing the gratuitous amount by not signing. That's what they're trying to do. It's sort of like when an ad says there's a limited time offer. If you don't call by X date, you won't get it. They're doing that to scare you into calling right away. So here's the thing: if your partner's mother is provincially regulated, then she's going to get 8 weeks by default. So what they're really offering you is 11 weeks. I would extra, and that's not a ton of money for someone who's 61 and was there for 19 years. But again, it could be because I haven't seen the employment contract. You need to get legal advice. You need to get it right away. Quite often, employers, you can ask for an extension of time and just ask for a 1 week extension, giving you time to get legal advice, and that should be sufficient. Almost always they grant it. Not always, but almost always. And with that extra week, you can get the legal advice you need. However, if you can't get the extension and you got to get an answer by Tuesday, talk to us. I'm sure we can get you. Talk to us at 1-855-821-5900. You can see it on the screen, employmentlawyer.ca, help@employmentlawyer.ca. I'm sure we can get you in. I mean, if something happens and you can't, like if you're in BC, I can make some time. I'm sure we can figure it out if you can't get the extension. Oh, that's my contact is on the screen, by the way. If you need to contact me specifically, you can do that. Just put your phone up to the QR code and my contact is there. But that's only if you're in BC. But contact us first, and we'll try to get you scheduled up. Okay, Carlos asks, my doctor had recommended working from home due to a permanent illness. I presented a letter and it was accepted, but recently they have been contacting my doctor without my knowledge to ask for further clarification. Can they contact my doctor without my consent? That's an interesting one. I mean, I think they can try. I don't know what the remedy is for that, but without coordinating with you. Here's my look at this, Carlos. I think that your employer is trying to figure out, maybe the political winds have shifted. They want you in the office, or they just don't want to deal with the situation anymore, and they want you out. But it's really complicated because of your illness and their acceptance of you working from home. They can't get rid of you without incurring huge liability potentially through the human rights regime. So, and different provinces have different rules and regulations around human rights liability. But I know in BC, there have been a few decisions that are terrifying for employers, just huge decisions. So depending on the egregiousness of the conduct by the employer. So when I look at this, I see it, or the cynical side of me looks at this and says, well, your employer is trying to figure out how to get rid of you. Or at least that's what it looks like. Now, you that's my impression, but I'm certainly open to being wrong. But they're probably going to ask you, for your doctor and you, to provide specifics of your injury, or maybe not so much your injury, but the accommodations you require to come back to the office, right? And so through that process, if they can say that your restrictions are such that they impair fundamental terms of your employment, they're going to try to get rid of you and say that your or they could try to get rid of you and say that your contract of employment has been frustrated. So they've already accepted. I'm not sure if you've got that in writing. I hope you have that in writing. I'm not sure really where they're going with this, or how much you have to comply with it. Generally speaking, beyond your doctor saying, hey, Carlos got to work from home on an indefinite basis, I don't believe you have to provide too much more. But Carlos, if this starts to go, like if they're insistent on more medical information, you're going to want to talk. You're going to want to have a lawyer in your corner. You should contact us right away and speak to one of our lawyers. Employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Medical cases are always the toughest. They're complicated. They come down to what's an essential term of your employment. What are the facts of and prognosis of your matter? But if it's permanent, this looks to me like, or I shouldn't say it definitively. It's entirely possible that they're trying to figure out a way to get you out of here. So yes, you're going to want a lawyer all the way through that process. So please contact us or a lawyer, an employment lawyer, as soon as you can, if they start asking for more information. I'll just say from your doctor, but what is, to answer your question specifically, can they contact your doctor without consent? I mean, anyone can contact anyone, but there's no remedy for you with respect to that. Might come up later in some in an actual claim, but your doctor's not going to provide anything without your consent anyway. So I wouldn't worry too much about that. Clint, I think, is back. Can one make a claim for constructive dismissal after resigning due to stress? Okay, Clint already answered that question. Clint is back. Last question. My toxic manager clearly had a bias towards me. She was attempting to build a phony case against me for my performance. Was forced to sign an HR document I refused to sign, that they didn't fire me, so I resigned. Yeah, I mean, Clint, how long ago did you resign? So if it was, I resigned in the heat of the moment, a week ago, and talk to a lawyer immediately, you might be able to. And this is where, I'm called to practice in BC. I don't practice anywhere else in the country. So I can't speak if you're what the law is where you are. But if you resign in BC under heightened emotional circumstances, and the employer knows that you're upset when you resign, Your resignation hasn't been perfected. So you can go back to them and say, oh, I didn't actually mean to resign. And then if you want to sort of preserve your right to potentially pursue some sort of wrongful dismissal if they don't let you come back. But those are tricky. The more time, that goes by after your resignation, the less likely that you can do that. It's something you've got to really act on quickly. These are complicated. You're going to want to talk to an employment lawyer right away. I will say, through this phony, people have bad managers all the time, right? Okay, Clint says he resigned at the end of March. Yeah, Clint, you need to talk to an employment lawyer next week, like right away, immediately. But phony case against for my performance. Well, they're just going to say it was legitimate, right? And it's tough to win on that. They didn't like my performance. I disagreed with them, so I resigned, right? Like that's a tough one. The employer has the power in its situation to negatively evaluate your performance, and that doesn't rise to the level, I think, of stress or let me rephrase that. Doesn't rise to the level that they repudiated your contract of employment. They have to be belittling you, acting terribly towards you, trying to cut you off from opportunities. There has to be, if it's your manager, there has to be, sort of evidence of your manager has some sort of vendetta against you. Like you've got to have more than just, manager and I butted heads a little bit over my performance. So those are always tough, but you might be able to undo the resignation if that's something that you want to preserve your potential right to severance. But then if they let you undo it, you just go back to work. So I talk to a lawyer next week. I do it as soon as possible. Again, for everybody, if you want to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855 821-5900. You're welcome, Linda. All the best to all of you as well. And with these are complicated questions for sure. Lots of complicated facts here today. So I wish you all success with those. I will be back. I won't be back in 2 weeks at a conference, but I'll be back certainly a month from now, if not sooner. Join us on Monday. Oh, I'm back next week. That's great. I'll be back next week on Friday, same time, 10:30 Pacific time. Join us next week. Chris Justice, Monday, April 22nd, 1:30 p.m. Eastern time. He'll be answering all of your questions, employment law with an Ontario focus. Thank you for joining us. As always, have a safe and wonderful weekend.